All right, today I wanted to talk about a subject that came up at the end of the class last week, and it's a legal doctrine called fair use. And even though we're going to be talking about some generic concepts involving fair use, which may not on their face seem as though they apply to structural and material science, I will bring it all together, you'll see. But in teaching these concepts, I'm going to be teaching them to you by using these general principles, because they're easier to learn, to tell you the truth. And ultimately, you'll see that there isn't any difference between political parity, for instance, as the concept of fair use applies to that, and quoting an author in a student paper. It's just, I think, easier sometimes to conceptualize these things in non-structural engineering and material science terms. But the concepts all apply equally. And once you've mastered the principles, applying them in any context becomes easy. Did I ever tell you why I started taking intellectual property cases in my law firm? When I was in law school, I had a 1967 Volkswagen Beetle. I don't know if any of you have ever driven a 1967 Volkswagen Beetle, but it's literally, I think, the last car made on the market that you can fix with like a hammer. It had 4 cylinders, it was air-cooled, and it was also unsafe at any speed, but that was the only transportation I had at that time. And one time I had to park it in the Prudential Center underground garage, which is still there. But back in those days, it was before the Prudential Center was the Prudential Center today. And when you'd go into the garage, the garage was divided into 2 halves. One half was public parking and one half was parking for the people that worked in the Prudential Center. And the 2 sides were separated by this big chain link fence. And it was dark and nasty in there at the time. And I drove my Volkswagen, because it was actually at the time a cheap place to park. I drove my Volkswagen into a space right up against the chain link fence where I could see over to the other side the cars of the people that worked in the Prudential Center. And as I got out of my car, I noticed that I was parked right across from a Lamborghini, a yellow Lamborghini. And I looked at that thing, and I looked at my Volkswagen, and I looked at the Lamborghini, and I looked at my Volkswagen. And I noticed on the Lamborghini there was a license plate in the front. Any idea what it said? IP law, intellectual property law. So it was because of that experience that when the first intellectual property case came into my office involving an infringement trial, I decided to actually take the case. Anyhow, I have an update on our student, our inventor student, who is in a dispute with a famous technical university located in Cambridge. In fact, I have 2 updates for you. I have an update for the beginning of the class and an update for the end of the class. The student, our student who's in this dispute, had after 3 years, the USPTO issued their patent yesterday. So now that student has a property right which is protected under United States patent law. And nobody can use this student's invention without their permission or without a license from them. So that's good news for our student. And as the rest of the story unfolds, I'll tell you what happens. And what we have to talk about today is actually somewhat related to that problem that I talked about on the first day of class. And that is the concept of fair use. Now, what is fair use? Fair use is a legal doctrine that basically stands for the principle that it's okay to infringe on someone else's copyrighted material in certain circumstances. And those circumstances depend upon the facts of each case, but they include a lot of things like commentary, criticism, things that enable us to talk about other things. Imagine what it would be like if you had to get an author's permission if you wanted to say something bad about what the author wrote or what they did. If you wanted to be critical of their research and question their findings and question their methodologies, imagine how difficult it would be to go to that author and say, look, I think you got it all wrong. I want to publish some criticism about your methods. I think that they're unsound. I think that your conclusions are wrong. Do you think you'd get permission from that author to use or cite their copyrighted works? I think it's less likely. So in terms of infringing on people's copyrights, oftentimes there are exceptions to that rule, and that exception is codified in a doctrine known as fair use. The First Amendment of the United States Constitution, I keep getting back to the First Amendment and to the Constitution in general because that's where intellectual property rights were codified for us. But the First Amendment protects people's freedom of speech. That means we can say anything we want whenever we want it whenever we want to within reason. But copyright restricts that right by prohibiting people from using certain works, except under certain circumstances. The only commonality between the two is to promote the wide dissemination of expression of ideas, the exchange of knowledge. Now, next week we're going to get into, I think I already mentioned it, the story of graphene and something called patent paper pairs. Whenever anybody files a patent these days, it's very common, especially in academic institutions, to also file a paper. A lot of people will do a doctoral dissertation. A lot of people will turn that dissertation into a scholarly work involving whatever it is that they're studying and publish it in the scientific literature. And the purpose oftentimes of publishing it in the scientific literature is, well, going back to Professor Eager's lecture on Monday, if you're looking for tenure, you know the old saw, it's publish or perish. So there, and of course recognition among your peers, advancing the state of the art. There's all kinds of reasons to publish. And there's a question, again, it's highlighted by this dichotomy here, whether or not patenting your inventions or copywriting your descriptions of them inhibits the spread of knowledge, of information. In fact, there's a very famous article by the Sloan School, where I went, that argues that intellectual property protections, like patents and copyrights, inhibits the dissemination of information. And we'll find out whether or not that proposition is actually true. But going back to this, that's the essential dichotomy that's involved in fair use. How do we protect the rights of people who have worked really hard to invent something or to describe it in an article, a scientific article, and at the same time promote the spread of knowledge and information? That's what we're always wrestling with when it comes to intellectual property law. And that's what that struggle is what's affecting you as inventors, as students, as researchers, as writers, because the rules that you have to live by are basically a compromise involving those two priorities. So the doctrine of fair use acts as the kind of like a First Amendment safeguard by allowing researchers, writers, inventors to infringe on others' property rights under certain circumstances. Not to get too technical about this, but in Title 17 of the United States Code, at sections 107 to 118, the Congress has described the balancing tests that the courts use when it comes to deciding whether some particular use involves fair use or involves infringement. Okay? And the four things that need to be considered and are considered in every case by every court that makes decisions on whether or not you're infringing or whether you're engaged in fair use are, they look at the purpose and the character of the use, they look at the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect that the use has upon the rights of the copyright owner. And these factors are weighed in each case to determine whether or not something qualifies as fair use. And the distinction between what is fair use and what is infringement is not always clear. As I said in the last class, the answer that most often is correct when it comes to this stuff is it depends. So I want to go through some of the factors that that illustrate this, so that when you're sitting there deciding whether or not you can actually use something, you'll consider these four factors and hopefully come to at least an informed decision of whether or not you can use it. But before I do that, let me give you some examples of fair use. Social or political commentary. Anybody read the New York Times or the Washington Post editorials or op-eds? How about the book 1984 by George Orwell, Animal Farm, another work by George Orwell, or one of my favorites, Fahrenheit 451. These are all examples of social commentary, which are protected by fair use. In each and every case, in 1984, in Animal Farm, and in modern times, how about the videos that PETA uses to promote their social commentary? All of that is protected in most cases as fair use. Search engines, Google, Bing, Yahoo, Ask. Have you ever heard of DuckDuckGo? Okay, so there's just some examples. There must be 20 search engines out there, but search engines, when they provide you with content, aren't infringing on anyone's copyright because they are considered to be fair use. Imagine where a search engine would be if every time they brought content to your attention they had to pay a licensing fee. Search engines would be non-existent. So this is an example of that dichotomy. In order to promote the spread of knowledge and information, we allow search engines to essentially infringe on people's copyrights, on your research papers, on the things that you write, on the things that you invent, the patent applications that you file are all available through these search engines. And although in any other context it might be considered an infringement on your intellectual property rights, it's not when it comes to search engines. Criticism, literary, artistic, political. I hated that ballet. That was a terrible book. I can say those things, and I can talk, and I can name the book, and I can actually take passages from it. This book was so bad because the author wrote this. I can do that and not infringe on anyone's copyright or intellectual property rights because I'm criticizing or engaged in commentary. Parody, political, social, literature, cartoons, The Daily Show, The Colbert Report, Larry Sanders, Shakespeare's Sonnet 130, which was, he made fun of love stories, made fun of himself, as a matter of fact. Don Quixote, another work that was written to make fun of love stories in literature. Gulliver's Travels made fun of traveling, essentially. All of those are considered parody or commentary. And again, none of them are considered infringement, even though they refer to protected rights or works, because they're engaged in commentary. News reporting, if you go home and turn on the news, there's clips being played all the time. Have you ever asked yourself, gee, how do they get these clips of the Oscars? When they are handing out the Best Actor or Best Movie Award, how do they play that? In some cases, they actually, depending upon how much they want to use, they have to pay a fee. In other cases, when they use a small amount of that footage that's made available from the Oscar, whatever the company is that owns the Oscars, they don't have to pay a licensing fee because it's news reporting. Researchers, okay, this directly applies, quoting another researcher's writings, their images, graphs, or charts. We're going to go into this a little bit more when it comes to plagiarism, because I think I want to cover plagiarism for you folks, just so that you have a working knowledge of it as you begin writing papers. Teaching and education, this class, and of course library and archiving. So let's talk about the four-part balancing test. Using copyrighted work for the purposes of criticism, I think that's pretty easy to see. That's generally fair use. A use that is more transformative, that is, isn't trying to convey exactly the same meaning, is likely to be considered fair use. Examples of transformative use of something that is protected is Marcel Duchamp's version of the Mona Lisa. Anybody familiar with that? Mona Lisa with the mustache? Well, here's an example of a work that is protected by intellectual property, but Marcel Duchamp wanted to he was sending a message which was, art is for the people, art is not, this rarefied thing that no one can understand. And he's kind of depancing the myth around art that existed at the time, trying to make it something that is considered available to everyone. So his criticism of the self-important reverence that the French bourgeois had for paintings and art in general and traditional European culture was the purpose. But he wasn't the only one that has used the Mona Lisa for commentary. This is Mona Lisa chess superstar with the chess pieces on her head. And this is Mona Lisa by Fernando Botero. Again, the purpose is social commentary, and a commentary on the world of art. So besides parody and criticism, non-commercial and educational uses are more likely to be fair use than commercial uses. And as I've already covered, it doesn't have to be non-commercial because they sell soap powder or in between news stories. What's the most, what part of the news generates the most revenue from ads? Do you have any idea?
Morning.
Well, what part of the morning? It's the weather. Have you ever wondered why you get 10 minutes of news and 20 minutes of weather? It's because the rates they charge for weather reporting is enormous. It literally funds the rest of the news. But what they use is all considered fair use, even though it's commercial and revenue generating in nature. The second part of the four-part test is the impact. So this is the factor that asks you to think about how your use could impact the work that you're borrowing from. If what you're making is a replacement, something that would steal sales attention from the original, then it's probably not fair use. Remember I put the Coca-Cola logo up there. Now I'm using that to teach intellectual property, so the use of the Coca-Cola trademark would be considered fair use. But of course, if I was selling a brand of soda using that particular logo or that trademark, that would not be considered fair use. How about if I took a famous artist who copyrighted their work, but never produced T-shirts. You ever see the smiley face T-shirts? I mean, are you old enough to remember that? Anyhow, in the olden days, the smiley face was a big thing. Well, in those days, what the owner of that property did is they copyrighted that work, the image of it. Then somebody had the idea of making T-shirts. Would you be able to go out and make T-shirts of an image that someone had copyrighted, even if they'd never copyrighted, never made T-shirts before? And the answer is you could not, because that would really affect the original work. Someone that trademarks or copyrights an image and maybe sells it on Shutterstock or Getty Images or iStock still is protected for other uses of that image. If you wanted to use the image to make fun of it or engage in parody or commentary, you could do that. But the commercial exploitation of something that is owned by someone else is probably a no-no.
So, what happens if somebody, for instance, tunes a little bit the contrast and brightness and tries to resell the image saying that it's different?
Well, it depends on how much daylight you put between the old image and the new image. And it also depends upon the use to which you put it. In fact, it depends on the four factors that I'm talking about right now. If the image is substantially different, that's one factor in your favor. If you're using it for something other than the purpose for which the owner of the image uses it, that's another factor in your favor, okay? But if it's for the same purpose and it's really not terribly different, it's probably not fair use. That's why I say that the answer to this question always is it depends. And it's these four factors that we all need to consider when deciding whether or not something constitutes fair use or infringement. So again, going back to the four factors, this is the third of the four factors. Consider the nature of the work. Use of a highly creative work, like a song or a melody, or words arranged on a page, like a poem, are less likely to be fair use of a heavily factual work, like a news story. So, for instance, if you're going to use a song that has been arranged by Prince or quote lyrics from a song that is protected under copyright, you're probably engaged in infringement. If you change the lyrics and keep the melody, or if you keep the lyrics and change the melody, then that might constitute a fair use, especially if the use to which you're putting it is parody or commentary or making fun of it, or somehow making some sort of judgment about the work itself. So again, it's less likely to be protected if you're really copying something that's complex, like lyrics or a song.
I've heard somewhere that you can sample a song, like up to 30 seconds, and as long as you give credit, that is okay. Is that true?
Giving credit does not make it fair use. So if you steal something from somebody and you give them credit, you're still stealing it, okay? The question is whether or not you're stealing it. And you're anticipating one of the factors. How much use of it you put is determinative. And the way, I'll give you an example. Duchamp's, if he wanted, in making his commentary on art, he had to use the whole Mona Lisa. You couldn't really just use like from her nose up in order to make that point that he was making, okay? Same thing with a song. If you're or a piece of code, or anything that you can copyright, if you use any more than you need to use in order to make your point, then you're probably infringing. And the more you use, the more trouble you're apt to find yourself in. 30 seconds, I think, is long these days. But if you were to use 10 seconds, I think that in this 4-factor test, that would be one factor in your favor. And if you get sued and a court is trying to decide whether or not you've infringed, you could say, well, I only used 10 seconds of it. You'd be in a much more difficult position if you say, well, I used 30 seconds of it, 10 seconds I needed, but the other 20 seconds was just beautiful, and it really kind of like made my spot better. Then I think you're in trouble. Yes?
So then when Vanilla Ice borrowed the dun 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 from Queen,
Yep.
I mean, it's really only, what, like a second and a half? So why is that infringing?
Well, it goes to this point, really. First of all, it was identical, okay? It's unique. See, again, it's why it depends every time. Now, in that case, there was a jury trial, and the question for the jury was, is this the same by the reasonable man standard? And what the juries get asked is, would a reasonable man think that this is copying? And in that case, it's such a distinct melody, and it was so precise in that they stole it, okay, that I guess it was an easy decision. Nowadays, when we try these cases, we have computer programs that we use in order to literally analyze what's being the subject of the infringement. So whether it's a melody or whether it's, I have cases where I've tried with copyright infringement where you literally take a whole book and the computer program, you scan the book in, the computer program will show you the identical passages. So that's the way we try these cases now. When it comes to music or even code, computer code, we have programs now to show the similarities between the original and the allegedly infringing work. And all I can say is the more daylight you put between yourself and the original work, the more creativity there is in it, the more likely it is that you're not infringing. But you've got to put daylight between you and the owner of the prior art, whether it's a copyrighted song, copyrighted software, a copyrighted photograph, a copyrighted book, whatever it is, you've got to add to it. You've got to change it. You've got to improve it. If you don't, and you just kind of steal it and put your own lyrics to it, you're probably going to get hit with a damage award in an infringement case. Yeah.
Does the intent matter if your intent was to steal or your intent was if you just have, I mean, the odds of you happening upon the exact same melody are slim, but
Yeah,
in a case like that, if then the person were to say, oh yeah, we didn't steal it, then is that already?
Intent only matters when it comes to multiple damages. Under the copyright laws and the laws involving infringement, intent of the infringer can be considered a mitigating or exacerbating element of damages. You're still liable for the monetary damages. In other words, you have to restore the owner of the property to the position they would have been in had you not infringed. But whether or not you get multiple damages or attorney's fees assessed against you under the federal copyright statute, intent is something that's considered. But whether or not it's infringement, intent doesn't matter. And oftentimes, a defendant will come into court and say, hey, million to one shot, which is what Vanilla Ice did. Million to one shot. Great minds had the same idea. If the work is protected by intellectual property, registration, you are presumed to be the owner, and there's no such thing as a million to one shot. Okay. getting to your question, it's like you had my slides in mind. How much do you use? Okay, so you only use what's necessary to make your point. Keep it short. The less you use, the better off you're going to be. Okay, getting into copyright. I've had people steal my clients' work, and I'll tell you the biggest abusers are the people in the scientific community. That publish or perish imperative that you're all under creates a lot of pressure for people to infringe, to produce writing and to cut corners and infringe. And I've had the worst abuses come from, I've represented some people in the field of, that belong to things like the American Medical Association and the American College of Veterinary Medicine and things like that, where publishing things professionally is important, especially for recognition in your community. And boy, cut and paste is a really common thing when it comes to professional papers. I see it all the time, and we use those programs to ferret them out. You can't just change "but" to "or" in a sentence and expect to avoid plagiarism or infringement. Yes?
Do you see a lot of instances of self-plagiarism as well?
Self-plagiarism?
Yeah, where like a scientist has written a conference paper, they use the same introduction for a journal.
Oh, yeah. But that's not really illegal. I mean, they're the owner of the content. It's not plagiarism because they're the owner of the content. It's laziness. And in some ways, that's worse than infringement or plagiarism in my mind. Hopefully every time I stand up in front of this class, it's different. And I always try to refine it. I try to make it interesting. I may not be very good, but I try not to be lazy. When you're giving speeches, which you will, everybody Googles everything that you've ever written before when they go in to listen to you speak. It's amazing. In fact, I've been Googled in class, every word coming out of my mouth, oftentimes when I misspeak, a hand goes up within 5 seconds in the back. So there's a lot, you have to understand your audience out there nowadays. It's different than the old days. And when I mean the old days, I mean 10 years ago. Everybody Googles what you've read, what you've written, and what you've said. And if you want to make an impact on people, if you want to be effective, be original. Don't be lazy. But it's not infringement. It's not, Yes, sir.
Well, going to court over someone else copying one of your academic papers seems like quite an extreme. Like, what damages were imposed on those the clients you represented?
Well, in that particular case, they were fighting over a trade name. And it was only valuable to the two parties. I swear to God, it was like watching two kids fight over a stick. Nobody cared. In the whole world, nobody cared whether somebody called it the American Academy of such and such or the American College of such and such. But the two parties were willing to spend millions to stop the other party from using college instead of academy. And in the same case, what they did when the rival organization created their bylaws, they literally stole the bylaws from the other scientific organization. And so let me tell you, there is no fury like two academics, especially well-heeled academics, fighting. Look at the Broad Institute in Stanford. I mean, while the technology is leapfrogging these two litigants, they're spending tens of millions of dollars on lawyers. Tens of millions of dollars. And a lot of that is vanity. The Broad wanted to make it clear that Stanford had not been able to demonstrate that their gene editing technique worked on mammals. Never mind the licensing that goes along with it, in cancer research and other things, because as we'll find, while you fight in court over a particular technology, there are end arounds being done all the time. And technology is leapfrogging all the time. I'm going to use the example of graphene that I mentioned the other day because that's one of the greatest examples in the universe for how technology leapfrogs and finds end arounds for intellectual property protection. Yes?
It's not really related to copyrights, but I guess on the topic of like what do you do if you're in a situation like this? Like in grad school, if you come up with an idea and then a couple years later you find out your advisor uses that idea without talking to you or crediting you but publishes it with another student, what recourse do you have as a, grad student with no money, no time, do you even, can you even pursue something like that?
Sure you can. Sure. Why, the main reason I find that people would steal in that circumstance is vanity and professional advancement. Usually not a lot of money involved in, that kind of stuff. But, there may be a promotion from assistant professor to professor, okay? And a strongly worded letter from you or your lawyer, which is very inexpensive, can have an awful lot of effect. Because the last thing anybody wants to be outed as is a plagiarizer or someone that infringes or uses other people's, in the groves of academy, nothing happens more often while at the same time being as anathema to the members of the groves of academy. So, at colleges and universities, I see so much infringement and plagiarism going on, and at the same time, these institutions consider that anathema to academics. So, the same institutions that absolutely deplore that practice engage in it the most. And to be fair, it's engaged in by those around the edges, to tell you the truth. In this particular example that I talked about involving the competing societies, one society literally stole everything from the other society and literally, instead of becoming experts in this particular medical subspecialty, because what it involved a whole new subspecialty of medicine that no one had ever thought of before. Like, there's orthopedics and there's pediatrics and there's, so a whole new branch of medicine was invented by somebody. The people that did the infringing really weren't experts in this. They were just in it for the vanity of it. And they literally were selling memberships in their society without testing the members to make money. And those are sort of like the fringe players in this thing. The vast majority of academics are honest, are hardworking, are conscious of these things, follow the rules. So, I kind of get involved in these things, but you can't deduce a general rule from my experience. I usually deal with, the exceptions to the rule. But in your case, the first thing I'd do is I would write a letter proving that you own it and showing how the person had taken the work without your consent. And then depending upon the circumstances, if it was intentional, if it was egregious, I might find a lawyer like me to ask them to send it out on their stationery, And you'd ask for something like an acknowledgement or, in fact, at the end of the class today, I'll give you an example of how that has actually happened and is related to our case, our little case study. So some examples of fair use. Anybody recognize that logo? Again, it's commentary. Maybe it's somebody that doesn't like chocolate or thinks Americans have a high-fat, high-sugar diet. I mean, there are lots of reasons why you would come up with that. Sort of explanatory, all right? But it's not infringement, It's not infringement because why is it not infringement? Help me out. Why is it not infringement? It's almost exactly like the logo. Why?
Is it because it's not like the guy is trying to sell like McDonald's with the same logo and like sell burgers? He's just talking about McDonald's. And I guess that would be
Exactly. You look at the four-factor test. It's commentary. It's parody or criticism. It's not a commercial use. They're not going to. They're not selling burgers, although they may cut into McDonald's hamburger sales. So yeah, on all it touches all four of those factors for fair use. That's the exact logo of WebMD. But this is an example of how you can take an infringement and turn it into a non-infringement by just adding a little original thought, which is convince yourself that you have a terminal illness. And where would we be without parody, comedy, and that sort of stuff? This is where the First Amendment tension and the dissemination of knowledge and protecting intellectual property rights, where that tension is illustrated. All right. I didn't actually. I had to figure that out. That was eBay. I didn't really know that was eBay, but yeah. So, say goodbye to your money. Say bye to your money. They don't all have to be criticisms either. When Steve Jobs passed away, this was sort of a tribute that was done to him. So they can have sentimental or altruistic or positive intentions behind them. Okay. Fair use in the public domain. If you Google almost any public domain painting, you'll find that many sites and individuals claim that they can charge you. Has anybody gone on a search engine and tried to download a picture of something? Well, let's use the Mona Lisa, for example. Who did the Mona Lisa? Anybody know who painted the Mona Lisa? And when was it? Well, and when was it done? Do you know when it was? Oh, good. It'll be something for you to look up. But what did we say was the limit of a copyright? Plus, exactly. I'll tell you that the Mona Lisa, okay, was done more than 70 years ago, and plus the life of the author. Okay, let's just take that for granted. All right, I'm going to let you go and look up who painted the Mona Lisa, all right? So how in heaven's name can they charge for a picture of the Mona Lisa? How does that work? The Mona Lisa is in the public domain, right? Yes?
To make some kind of claim that they like the service, they provided it to you.
Yeah, not bad, not bad, yes.
We provide the value of finding this for you and giving it to you, so therefore we get to charge for it.
That's pretty close. That's pretty close. And I don't know if that argument passes the straight face test as far as I'm concerned as a lawyer. Because if it's just a slavish reproduction of something that's in the public domain, I don't think you can charge anybody for it. So, but what museums, the Mona Lisa is owned by the Louvre in France. And they charge a licensing fee for photographs of the Mona Lisa. They claim that those photographs that they sell of the Mona Lisa are art in and of themselves, for which they own the copyright and can charge a licensing fee. Remember that case we talked about with Happy Birthday? All right, someday somebody is going to stand up and they're going to say, you can't do that. And that day has actually come. Because in this case here, back in 1999, now this is only a district court case, so that it's not a Supreme Court case, but in this case, the federal district court in the Bridgman Art Library versus Corel Corporation found that exact reproductions of public domain artworks are not protected by copyright. And This case was never appealed because the losers didn't want to have the Supreme Court affirm this. What they wanted is to maintain sort of like this vague, kind of weird, area of the law that's not really clear at this point. If you go to some museums, you look at the back of the ticket and it says that the museum reserves the right to control all of the images. Oftentimes they'll ban photography equipment in order to protect what they view as an exclusive license to reproduce the images that they have. Other museums you're allowed to take pictures. If you take a picture of the Mona Lisa, are you violating a license or copyright or any intellectual property? Yes? Why?
If there's a setup or something that they design around it that you capture within the frame, then they could argue that this is something that's in addition to the aesthetic. So it's not an exact reproduction, and therefore
Well, you make a good lawyer for the defense. I think that's a very creative way of looking at it. But my view is if you look at the four-factor test, there's no originality. There's nothing. You're just taking a picture of something that's in the public domain. You own it. If you want to take that picture and sell it on eBay, I think you can do it. Good luck to you. Make as much money as you possibly can. But so this case talks about how exact reproductions of something in the public domain, but it has to be an exact reproduction. You seized on the proper word. If it's not an exact reproduction, if it adds something, if it creates greater depth, if it has some sort of intrinsic artistic value or adds to it in some way, you might get an argument that it's not. But the photos have to be flat, artless reproductions. They can't be enhanced or done up. And despite this, museums and other institutions and individual photographers still claim, or at least imply, that they're slavish reproductions of photographic images, of public domain images. They can charge for them. Yes?
So basically, it means they actually just get away with it unless someone takes the tax.
Exactly.
It doesn't matter. Whatever you're willing to pay is what they can charge.
Exactly. What if you're going over the Golden Gate Bridge and somebody sets up a toll booth, or the Brooklyn Bridge and somebody sets a toll booth up right in the middle? Would you pay the toll? I think a lot of people probably would, but you don't have a right to do that. But it's the same thing. It's like putting up a toll in the middle of the Brooklyn Bridge, or selling somebody exclusive rights, copyright rights to the United States Constitution. There are people. There's a book out there. I can't remember the name of the author, but there's like 1,000 examples of where people have done stuff like this, and it's just that people they're used to paying for Happy Birthday. They're used to paying Shutterstock or the Einstein Family Foundation for using images that really are in the public domain, and they just do it, I guess, for convenience. So coming back to our case, you ever heard of the term Skunkworks? All right. Well, it happens that Skunkworks is a trademark of the Lockheed Martin Corporation. And you know how Fortune magazine knows it? They published an article where the title of it was, "What's that bad odor at Innovation Skunkworks?" And they got a letter from the lawyers for Skunkworks. And the reason I mention this is because in a letter that my office received from a famous technical university arguing their case, they actually used the word Skunkworks. And as an intellectual property lawyer, or somebody that at least knows enough about intellectual property law to be dangerous, receiving a letter from somebody that is supposed to know about intellectual property law, using the word Skunkworks in a letter struck me as sort of funny and interesting, because apparently this other attorney does not know that Lockheed Martin owns the rights to this. And so using the phrase sort of carelessly indicates to me that they don't really know that this is actually protected. And by the way, another fair use of things, court proceedings, court filings, things like that, that would be, I wouldn't be able to try a case if I couldn't bring into court and show the material that was copyrighted. But it's still kind of careless to like throw words around in letters that, that other people might realize indicate that you don't know anything about intellectual property law. So anyhow, this is a corporate nightmare, and I just wanted to give you some other examples of things like Skunkworks that you may have heard about, because it relates back to what we were talking about in the last case. In the last case, cornflakes, Kellogg's owns that. Aspirin, Bayer owns that. The Yellow Pages, the Yellow Pages owns that. How about Xerox? You ever tell anybody, go make me a Xerox of this? Everybody knows what you mean. All of these phrases have joined the common nomenclature. But oftentimes what happens, as with Skunkworks, is when you use these phrases in something that you write or something that you produce or some form of media, you get a letter from a lawyer saying, please don't use that, or the next time you use that, like they did with Skunkworks, please make sure that you indicate to your readers that it's a registered trademark of Lockheed Martin, or Kellogg's or Xerox. Xerox has spent millions trying to get people to not use its term as being synonymous with copying. Anyhow, so on Friday, we're going to talk about we're going to start talking about patents in more detail. We're going to talk about the Coke bottle. And next week, we're going to learn how to actually file a patent application. So I'll see you on Friday. Thanks. And thanks.